All right, let's dive right into this explainer. Today, we are unpacking a truly massive shift in the Indian justice system. We're talking about the transition from the old Criminal Procedure Code to the brand new Bharatiya Nagarik Suraksha Sanhita, or the BNSS. This is a big deal because it completely remaps how personal liberty is negotiated in the courts. So whether you're a law student, a legal practitioner, or just an informed citizen, understanding these new rules is absolutely vital. You know, the Supreme Court really hit the nail on the head back in 2022. In the landmark case of Satendra Kumar Antil versus CBI, the court boldly reiterated this exact phrase: bail is the rule, jail is the exception. It's a great reminder that at the very center of all these incredibly complex statutes and procedures is just a profound, basic respect for human freedom. So we've got a ton of statutory law to cover today. We're going to break it down into 5 parts. First, the right to liberty. Second, the 4 types of bail. Third, the new BNSS framework. Fourth, the bail application process. And finally, what happens when bail is denied. Let's get right into it. Starting off with Section 1, the right to liberty, and exactly why bail even exists in the first place. As Justice V.R. Krishna Iyer so eloquently noted, having a developed jurisprudence of bail is integral to a socially sensitized judicial process. The whole object here is just to secure attendance, right? It's not supposed to act as a premature punishment. You see, depriving someone of their liberty is a punishment, and it's completely contrary to the presumption of innocence to punish someone before they're actually tried and found guilty. So think of bail like a bridge. The state obviously needs to ensure you actually show up for your trial. But on the flip side, you have a constitutional right not to be locked up unnecessarily. Bail is simply that monetary or personal assurance that bridges the gap between state power and your individual liberty. Now, as an accused person, you are armed with these 4 fundamental rights, which act as essential shields to ensure you aren't kept in custody for some unreasonably long time without a trial. Actually, the landmark Husainara Khatun case from way back in 1979 established that a speedy trial is a fundamental right under Article 21 of the Constitution. So if you're arrested, you have an absolute right to be informed if your offense is bailable and the absolute right to consult a lawyer. Moving right along to Section 2, the 4 types of bail, which covers the mechanical structures of how this all actually works. This is where we get into the classic rule versus exception dynamic. It's vital to understand this. If you're accused of a bailable offense, bail isn't just a privilege. It's your absolute right. The police or the magistrate have a mandatory duty to release you. But if the charge is non-bailable, say something like murder or a serious fraud, then the judge steps in. They have to weigh the gravity of the crime, the strength of the evidence, and whether you're a flight risk before deciding to grant regular bail. Now check out this statutory default bail timeline. It creates a highly urgent framework, basically a ticking clock for the police. If the investigating agency fails to file the charge sheet within these 60 or 90-day limits, the accused gains an indefeasible right to statutory bail. It's often called default bail, and it is an automatic right. Like it was established in the Uday Mohanlal Acharya case. The moment that clock strikes midnight on the 60th or 90th day, without a charge sheet, the court absolutely must release the accused if they can furnish bail. All right, Section 3. This is the big one. The new BNSS framework and the major 2024 updates. If you're already familiar with the old CrPC system, this transition is actually pretty seamless. For example, you've probably heard people talk about a Section 438 anticipatory bail. Well, under the new BNSS, that exact same thing is now Section 482. The core principles of justice haven't changed, but the numerical scaffolding has been completely updated. Let's zoom in on BNSS Section 482 for a second. This is your ultimate shield against malicious accusations. And here's the crazy part. You do not even need to wait for an FIR to be registered to seek this protection from the Sessions or High Court. Based on the historic Gurbakh Singh Sibia case, if you have a credible, reasonable fear that you'll be arrested on false accusations, maybe because of a professional rivalry, you can proactively approach the court. If they grant it, it essentially means if you are arrested, you'll be immediately released on bail. So that's the law. Now for Section 4, the bail application process and the practical steps to actually get it done. Timing is literally everything here. For regular bail, you generally want to file an application within 24 to 48 hours of being taken into custody. These 4 chronological steps are exactly the playbook an accused and their lawyer need to execute. It's a highly adversarial process. Your defense lawyer fights for your liberty, the public prosecutor fights for the state's interest, and the judge sits right in the middle as the neutral referee. Ultimately, what the courts are looking for is stability. They need to know for sure that you aren't a flight risk. Providing really solid documentation, like proof of employment, a fixed residence, or medical records if you're seeking bail on humanitarian grounds, gives the judge that necessary confidence they need to sign off on your conditional release. Finally, Section 5, when bail is denied. Let's talk about rejection and appeals. So, what happens if the judge says no? If bail is denied by a lower court for a serious reason, like the offense being extremely grave or maybe the accused is a repeat offender, the system still gives you a structural pathway to appeal to a higher court using new facts or legal grounds. The BNSS actually grants special concurrent powers to the Sessions Court and the High Court. So if a magistrate rejects your bail because they think you might intimidate a witness, your legal team can appeal upwards and introduce new arguments to mitigate those specific concerns.
And here's the kicker. Even if you do get bail, it is definitely not a permanent free pass. It's highly conditional. If you abuse that privilege of liberty by trying to derail the investigation, tampering with witnesses, or attempting to flee the country, the court has the absolute authority to revoke your bail and toss you right back into custody.
So I want to leave you with this final question to chew on. Do these new BNSS laws actually do enough to balance the immense power of the state with our fundamental right to personal liberty? I really hope this explainer has empowered you with a much clearer understanding of your legal rights. We've traced the philosophical roots of liberty, decoded the new BNSS sections, and walked through the practical realities of the courtroom. The law is a living, breathing thing, constantly trying to balance public safety with individual freedom. Thanks for joining me today, and as always, keep questioning and keep learning.